Welcome to my webinar. I'm Oliver Price. I'm a solicitor and lawyer based at Wansbroughs in central Wiltshire. I'm delivering this webinar about the new EU General Data Protection Regulation, the GDPR. Now, it's helpful for you when looking at this webinar or beforehand to have access to two documents. The first is my practical guide, which takes you through the new changes and things that you need to think about in your business. A second is a worksheet, a 10-point worksheet, which enables you to start making plans for what you're going to do in respect of these changes and in your own businesses. So in this section I'm going to take you through an overview of the new EU GDPR. Some slides will appear as I go. I'm going through the main changes as a result of this new legislation. You'll see from the first slide that this is quite a significant large body of new legislation. However, I'd ask you not to be put off by that, because we've still got in the UK the Data Protection Act from 1998 and a number of the core and key definitions like what is data are still there from all of that legislation. So there's a lot that hasn't changed, things like what is data, all personal information relating to a natural person. In most cases, you are going to be a data controller, and so the focus of this section works on the basis that you're a data controller. That is, like many businesses in the UK, you've got staff, you've got customers, you're dealing with data. You can also be a data processor. Now, the simple definition for data processor is someone who handles data but doesn't have a day-to-day interest in it. The obvious example of this is your IT suppliers. So they are data processors, but the focus of this talk is for you as data controller. As I said, the existing law is all still in place. The new law is additive, and so there are a number of things that have been changed and added to as a result of the EU GDPR. So what is changing? I'm focusing here on a few myths and areas of significant interest through the series of seminars and talks that I've done over the last 6 months. One of those is about consent. There's been an awful lot of myth about consent, and I actually invented a word, over-consentivization, because a lot of businesses have just reached for consent to do everything. In particular, in relation to managing staff, it's my view that you should not be generally using consent. It is just so burdensome, because the number of bits of information you need to give, how you need to maintain consent, is very burdensome, and you're therefore better relying on other grounds. So, what are the other grounds? You'll see from the slide that there are 6 grounds, one of which is consent. So I want to focus in on a couple of those. One is performance of a contract. Now, in the HR and employee section, you'll always have a contract of employment in place with any staff and employees. And that gives you a convenient way to be handling data. And because the significant rights that individuals have in relation to their data, from a business point of view, you're far better relying in the employee sector on either performance of a contract or legitimate business interest. Performance of a contract also enables you to handle client and customer relationships by performing a contract with them, which is what you're always doing, without just reaching for consent. So where does consent usually come in? Well, typically consent needs to be used when we're talking about marketing, because if we're marketing our businesses, generally we're going outside simply performing a contract for clients and customers and those that we're doing business with. So if you're holding onto a marketing data set or you're buying marketing data sets to develop your business, you need to consider carefully whether you need consent for that. You'll realise that I haven't said that you must have consent for marketing activities, and it's certainly not the case that you have to. And here at the moment there are some useful guidelines from the Direct Marketing Association if you're dealing with very large marketing data sets, as well as from the ICO that are set out that, generally speaking, you're either going to be looking at consent or considering your legitimate interest. There are a couple of problems with both consent and with legitimate interest. As I said earlier, consent is really quite burdensome, and the problem for legitimate interest is that it's easily overcome by the individual's rights. So if they don't have a reasonable expectation that what they're getting from you without their consent in relation to their data, and typically we're talking about marketing output, emails, SMS texts, all those sorts of things, contacting people, using the data, processing their data to get in touch with them to advance your business. That may well start to be with your legitimate interest, but if they don't have a reasonable expectation to receive information from you, then very quickly legitimate interest can disappear. Now that's a developing area, and it's one area that I'd say you just need to keep a track of the developments as the new law comes into force, because of course whilst we've got a certain amount of guidance, it's only after the 25th of May that this new law is really going to settle in. We're really going to understand how far we need to go with consent for marketing activities. But remember in this section that you need to go back and think, do I actually need consent? Is it reasonable to get consent for the activity I'm dealing with, or can it be covered by one of the other grounds? So next, what else is new? So there are a whole bag of new rights for individuals, and the EU's drive here is the protection of individuals, and you have to remember this as we're looking at these new rights. Many of these new rights are expansions of existing rights, so there are only one or two that are entirely new. So for example, data minimization, the idea that you've got to keep data to a minimum, and also data accuracy, you've got to keep individuals' data reasonably accurate. Those sorts of rights have been with us for quite some time. There are a couple of new ones that I think are going to require people to think carefully in their businesses about how they're dealing with data. One is data portability. This can arise typically with banking or mobile telephones, and this is all about individuals being able to say to company A, where a service is moving typically to company B, so bank or mobile phone accounts are the obvious ones, please move my data as I go from company A to company B. So if you've got customer or client relationships where they regularly transfer between different companies, you need to consider carefully how you hold data in your systems and that you can move that data reasonably swiftly. Now, essentially all of the rights on this slide that are being strengthened or introduced, if an individual says, I want to exercise this right, as a business you've then got 30 days to respond to that request. So for example, the new right to be forgotten, the right to have data erased, which in my view most businesses won't need to be concerned about too much. I think this is going to be a right that will only apply to certain businesses where people particularly want to be forgotten, and of course it comes from the Google case where an individual wanted Google to forget his criminal records data, the metadata that was held about him in Google. It's only those sorts of businesses, large processors, that are likely to be significantly affected by the right to be forgotten. But if that's exercised, that needs to be dealt with within 30 days. Now that period contrasts with what we come to in respect of data breaches in a moment. So what else has changed? there are a number of things that, specific things that have changed. One of them is subject access requests. So this is about individuals wanting a copy of the data that you as a data controller hold about them. Now, typically subject access requests, or SARs as they're called, arise in two situations. One, and the most common one, is in HR and employment law, and usually in an employment dispute there is a request for a copy of the data file. The other is in health-based organisations. So if your business deals with health or health data, this is something that's likely to affect you. Currently they require a 40-day period, so you can respond to the SAR up to 40 days after you receive the request. £10 or potentially more has to be paid. Typically these are now free, they have to be responded to within 30 days. So just moving through these changes, the next one is data security. So the GDPR really strengthens requirements to keep data secure. And that's one of the things that reflects the changes in computing over the last 20 years. I joined my business 19 years ago, and I reckon that we spent more on coffee when I joined my business than we did on IT. I'm quite sure we now spend considerably more on IT. So we didn't have an IT team. We now have 4 people working in a business that has about 100 people. We're changing all our computer systems this year, spending 6-figure sums as we go on IT. We're really in a different world, and so the opportunity for data to be secure is recognised in the GDPR. So you have to consider, when it comes to the 10 practical points that I'll come to in the next section, quite carefully what your data security arrangements are. Are you encrypting data? So when you're dealing with your customers or clients' data, what then happens with it in terms of security? Do you encrypt it? Do you key code it? What's your password policy? And this is one of the most significant changes. You need to consider carefully how you're dealing with this area. The other thing for larger businesses, so if you've got over 250 staff, is there are quite considerable requirements for record keeping. So you need to keep records as you go, and there is a lot of guidance available about how to keep these records. With smaller businesses, it is lighter touch. However, it's always wise to be keeping good records as you go about all of this. The next section is data breaches, and if I asked you what before the 25th of May do you need to do if you have a data breach, so for example we all have mobile phones and computers. I've got my computer on my desk here. If I go off to a restaurant, leave my car outside with my computer in the car, and I lose it before the 25th of May, if I committed some data breach, I didn't need to tell anyone, so I didn't need to say anything about that, and that's all changing quite significantly. So after the 25th of May, if there is a data breach in that same situation where my laptop or phone is stolen and it contains data, then within 72 hours, so that's 72 hours, day or night, Christmas, Easter, weekend, it's still 72 hours, and as quickly as possible we have to be able to tell the ICO that we had a data breach. Now there is a difference between the current ICO guidance and the law on this, and I asked 5 months ago the ICO to clarify why there was a difference, and I'm yet to receive a clear answer on this. But the law, the legal requirement, is that regardless of significance, once there is a data breach that affects the individual's rights, so their rights have been infringed in some way, and essentially that's what will happen if there's a loss of data. However it's lost, then you need to tell the ICO. What the ICO says is only tell her in a situation where there is a significant risk to the individual. So there is a bit of a difference. We'll need to see how that works in coming months. As well as telling the ICO, you'll remember before the law came into force, I didn't need to tell anyone. Well, again, that's changed in relation to the individual or individuals affected by the data breach. And you now need to consider whether it's high risk to them. So you've got to make a value judgment, determine whether that's a high risk breach. If it isn't, you don't need to tell them. If it is, you do. So what is high risk? For me, that comes down to the sort of data that we're talking about. So let's say you've sent an email accidentally, and typically this can happen in Outlook because of the auto-filling of email details to the wrong individual about another. It doesn't contain any significant information in that email, but it does identify another individual. To my mind, that's a very insignificant data breach. You don't, in that situation, normally need to tell the individual affected about that breach. But let's say in that situation, I've sent the individuals affected credit card details. So I've put in high risk, significant data. It's a significant high risk breach. It's clear from the cases that and the guidance that we should be telling individuals about that data breach. Some other things that have changed. You also need to consider appointing a data protection officer. The guidance on this changed, I should say, the rules changed just over a year ago. It was originally going to be, and it's wrongly been reported widely, that it's a requirement to have a DPO if you've got over 250 staff. In fact, that's not the case. It's now about whether you process a large amount of data. So if you hold a significant amount of data, and typically that might be because you're a data processor or a larger business, or you just process high-risk data like health data, criminal records data, sensitive data, those sorts of things, then you need to appoint a data protection officer. Now I'll say here, even if you don't appoint a data protection officer, it is a wise move to have someone in your organisation, that might be you, or someone else who regularly deals with compliance. That might be HR. A lot of people are deciding that the HR department needs to do this. Then have someone responsible for this area. Now in my business, I've been appointed a data protection officer, and I've got to oversee how we manage data and also deal with a breach if that happens, and deal with training. But I've also appointed a data protection manager, someone who can deal with the day-to-day, and also if I'm not here, I'm on holiday, I'm away, there's someone here who has a sufficient grasp of this area to be able to deal with inquiries or breaches as they arise. In this section, I'm going to give you a few cases and tell you what the fines were levied by the ICO. The cases that the ICO has dealt with in the last couple of years tend to fall into three different categories. The first of those is a data hack, a cyber attack, some attack that's led to a data breach, a loss of information. The second is problems over compliance and consent. Classically, consent is raised as an issue, and this can come up through direct marketing where insufficient care has been taken to work out whether there's legitimate interest or whether consent is required. The third, which I'm not really going to dwell on, is really about criminal activity. Criminals who buy and sell large data sets without any care about how they've been created, that sort of thing. And I'm not going to be dwelling on those too significantly. So the first case I'll mention is Carphone Warehouse. So in 2015, Carphone Warehouse had a significant cyber attack from an organised criminal gang, it's believed based in Vietnam. They got into the Carphone Warehouse computer system. Unfortunately, the Carphone Warehouse systems to deal with password and security over passwords was not very good. So they had, the decision says, about 30 people holding the same password at the same time. So a number of people could easily access systems. It was very easy for criminals to get in, look around and get sensitive information about individuals. Sensitive means financial data, so there was a significant breach. The fine in that case was £400,000. In a similar way, Construction Materials Online in Plymouth a couple of years ago also had a data hack. Some 669 customers who visited their website to buy, it's understood, building materials online, so it's a bit like an online B&Q, something like that. 669 credit card details were compromised. There was a significant data hack through an SQL problem on their website, and again, password, as with Carphone Warehouse, password policies were inadequate. In that case, the company is much smaller, and the fine is £55,000. Now, all of these fines get reduced by 20% if the companies pay them on time, which I'm sure they did. Now, the next case is Honda. So, the problem that Honda had was a message going out to all individuals held on their marketing database, some 343,000 email details, it's understood from the decision, was a message was sent out saying simply, do you wish to hear from Honda? Honda took the view in the case that that was a service message. The ICO took a different view, that that was a marketing message, and that the marketing stretched outside fair processing and outside, in many cases, the consents that had or hadn't been obtained in showrooms and in other places where Honda had obtained those details. So they had a problem with consent. And it's perhaps an unusual case, and it comes under the old law, but this is likely to happen again with large marketing data sets. Now, in that case, with so many emails, you'd expect there to be a significant fine. Remember, the current maximum at the time was £500,000. The fine was only £12,000, so significantly lower than the fines for data breaches. And the point there is to think carefully about your own risks. Where do your risks lie? So if you're in B2B, and you deal with marketing and personal information in B2B, it could be said that based on the decisions that your significantly greater risks of a high fine are to do with cyber risks and a cyber hack and what you do to protect your computers from that sort of activity. So in this section I'm going to take you through the 10-point practical guide sheet. It's useful prior to watching this section of the webinar that you've picked up the 10-point practical guide, read through it, and also made some notes about things that you believe that you need to do. I'm then just going to talk through those 10 points so that you've got some guidance from me on what those are all about. Most of them are self-explanatory, and it's true that in the area of data protection, a general rule is whenever you're dealing with data, how does it feel? Does it feel right what you're doing or not? Based on this large body of legislation, it's still really about common sense. So a lot of this area is about following what you feel is right. Because if you put yourself in the shoes of the data subject, so typically your member of staff, or your customer or client, is it right for them? So are they happy to receive those marketing messages? Are they happy what you're doing with their data? If they've consented, does the consent go far enough for the processing, the activity that you want to do? So as a general point, just stop and think every time you're dealing with data. So the first point here is a very obvious one. Is everyone in your business, in your organisation, aware of the change taking place with the EU GDPR in 2018? It's worth just reminding them that there are now significant fines, that it can really affect business if this area is got wrong. So if there is a breach, or we don't have consent for something that we should have consent for, or a good reason to process data, this is something that could really go badly wrong. The second point is an information audit, and this is a simple enough thing to do. So you're simply considering in your business, where do you hold data, how do you process it, what is it? And we're talking about data in organised filing systems, not messy desks. We're talking about computing systems, talking about filing cabinets of the like I've got behind me, so I have lots of those in my business. We hold lots of client data. So you've got to audit those, not each one, but in categories. So you've got to look at where your HR data is held, and then consider what the arrangements are for holding that data. This will probably lead you into a couple of places. One is archive stores. How long are you keeping data for? Where is it? The other is it will lead you to think about third-party IT arrangements. So classically, your web hosters, those who deal with your email, those who deal with your computer firewall, or offer you the whole suite of services, because typically those may come from one company. But you may be surprised, I certainly was. For example, we have here as lawyers a thing called DocSafe, holds clients' information safe. It's held in Germany. I was surprised about that. I thought that was held in the UK. So once you've done your audit, that naturally leads on to the next point, which is data security. So you need to be thinking about areas that you hold data. How secure is it? Do you need to be encrypting data, particularly with emails? That can obviously be a route for information to be lost, and so you've got to consider that. The next one is subject access requests. As I mentioned earlier on, this is a specialised area. Typically, this is going to come in HR. They need to know that there is new documentation for dealing with this, because the documentation that you had before the 25th of May won't be up to date. It's free. The period for dealing with it is shorter. It's 30, not 40 days. So that needs to be put in place. And that leads on to the next point as well, documentation generally. And there are typically a couple of simple categories of documents that you need to consider. If your business is online, ours is, most are, you need to have an up-to-date website privacy policy. Secondly, if you're dealing with customer or client contracts and you're receiving their data, it's usual to have a privacy policy in place. Now, you may well not need consent, but you do need to be informing companies and individuals what you're doing with their data, the arrangements for you holding their data, and typically that's in a privacy policy. If you're then going on to do marketing, as I mentioned in the talk earlier, that may or may not require consent. If you believe for your marketing that it will, then you also need to consider, and at the earliest stage when you're making a contract, it's the sensible point to do it. Get consent for those activities that you need. So the sixth point to consider is if your business is dealing with children. Now, a child in the EU would be over 16. In the UK, that's 13 is the threshold age for children. And there are a couple of things to consider. One, whether you need consents from adults, and secondly, typically online, you need to consider in relation to your website whether your website pointing at young people and children, and if so, whether you need to have click-throughs to confirm the age of the person you're dealing with, and potentially parental consents if the product or service that you're selling needs consent from an adult before a child is involved. So the next point is data breaches. You've got to have a system in place. As I mentioned earlier, the periods for data breaches are very short, 72 hours. You've got to report these things as quickly as possible, potentially. So someone in your organisation needs to be in a position to deal with data breaches. The eighth point is about geography. If your business has offices or a presence elsewhere, either in the EEA area or outside the EEA, there may be different rules. In the EEA, I expect it's simpler because this is EU-wide law, the GDPR. Once you move outside that area, for instance, to the US, they have significantly different arrangements, like the US Privacy Shield. You need to be aware if data is, particularly if data is transferring between your offices, what the arrangements are for transfer, and going back to the individuals whose data that relates to, that they understand the data is transferring, particularly outside the EEA area. As I mentioned earlier, you may or may not need to appoint a data protection officer, a DPO. Whether you do or not, you need to consider carefully who's going to pick up responsibility in your organisation for this new law. The last point is just keep up to date. A number of ways you can do this. I regularly blog and vlog now on changes and things and developments in this area. The ICO website is also useful. There are a number of other websites. You should also look to your professional advisors. If you've got lawyers and other people helping you, you should ask them to confirm what they can do to help you in this area, both to get ready, but also with any documentation that you need. Thank you for watching my webinar, and all the very best for getting ready for the GDPR, either before or after the 25th of May 2018. There's plenty of other help available. You can always contact me either through the Moodle or via our website or from my email, which is available at the end of the slides and in the practical guide.